Hello, I am Indrajit Narayan Singh from YouTube. These days I am giving you landmark judgment Sarfaesi Act 2002. Today it is serial number 10. Please hear and follow the landmark judgment. This judgment will be beneficial to the examinee of CAIIB and JAIIB judicial examinations and civil service examination. Cause title of judgment: Vishal N. Kalsaria versus Bank of India and others. 2016 3 SCC 762, decided on 20th January 2016. Issue: Tenancy right vis-a-vis Sarfaesi Act 2002. In this judgment, the Honorable Supreme Court considered the conflict between the scope and application of Sarfaesi Act 2002 and the Maharashtra Rent Control Act 1999 and or other state rent laws. The aspects of the observation of the Honorable Court are as under. The Honorable Court observed that in the said matter, the lease deed was not registered. The Honorable Court interpreted Section 106 of the Transfer of Property Act 1882 and stated that when a monthly tenancy is reduced to writing, it must be registered. However, the onus of registration vests with the landlord as per Section 55 of the Rent Control Act. Hence, the tenant cannot be held liable for non-registration of the lease deed. The Apex Court also held liable for non-registration of the lease deed. The Apex Court also held that where the monthly rent was paid and accepted regularly, then mere non-registration of the lease deed would not negate the said lease. The tenant would still be protected under Rent Control Acts. The Apex Court held that a tenant who is protected under the Rent Control Act can only be evicted after following due process as established under the Rent Control Act. The overriding provision provided under Section 35 of Sarfaesi Act 2002 can not be invoked to nullify the protection provided by the Rent Control Act. In a scenario where the Sarfaesi Act 2002 is said to prevail over the Estate Rent Control Act, the tenant would always bear the brunt of failure of their landlord in paying dues to the banks, financial institutions. The financial institution would then take recourse under the Sarfaesi Act and evict the tenants. Hence, the tenants would live in the fear that their landlord might mortgage the premises they are living in, and on default, the tenants would be forced to give up possession of such premises. In order to protect the interest of tenants, Rent Control Act have enacted by several states. If the Sarfaesi Act was allowed to prevail over the Rent Control Act, when the legislation power of the state legislative is declared, hence it could not be held that Sarfaesi Act 2002 would have an overriding effect over. Today, you have heard landmark judgment of Sarfaesi Act 2002. Now please subscribe, then I will deliver another lecture on landmark judgment very soon. Thank you.